Welcome to The Explainer. Today, we are diving headfirst into the world of Ontario real estate. And let me tell you, it's a legal minefield where your common sense can actually cost you a fortune.
You know, this quote right here, it's the whole story. The law is not always intuitive. It is procedural. What that really means is that in Ontario real estate, what feels right is often dead wrong. One tiny procedural slip-up, it can lead to some seriously disastrous consequences. So here's what we're going to tackle today. We're busting 4 huge myths. First, the power structure in your condo, who's really in charge. Then, how investors actually value a property. It's not what you think. We'll get into the tricky business of evicting a tenant. And finally, we'll uncover the parts of your own property you might not even own. All right, let's jump right in. Okay, first up, the condo power myth. We got to understand who really runs the building. And you know, a condo isn't just a place to live. Think of it more like a 4th level of government. Seriously, it has its own constitution, its own laws, the whole shebang.
Now this is where so many people trip up. They use the words bylaws and rules like they're the same thing. They're absolutely not, and getting it wrong is a critical mistake. Think of it like this. The bylaws are the constitution for the condo corporation itself, big picture stuff. The rules, that's the day-to-day legislation that governs how you live. You know, things like noise, pets, that kind of stuff.
Let's make this super practical. Say the condo needs $1 million loan for a new roof. Well, that affects the entire corporation's finances, right? So that's a bylaw issue. It needs a full vote from all the owners. But what about banning your neighbor's 2 a.m. drum solo? That's about resident behavior, keeping things orderly. That's a rule issue, something the board can propose on its own. See? The difference is absolutely huge.
Okay, so if you're thinking about buying a condo, you are going to hear about this document. It's called the Status Certificate, and it is absolutely crucial. It's basically the unit's health record. It tells you everything you need to know about its financial situation.
And the law on this is incredibly specific. The condo corporation has exactly 10 days to get that certificate to a potential buyer. Not 11, not 9.5, 10 days. That's it.
So you might be wondering, what happens if they're late? I mean, commerce has to move fast, but getting this stuff right takes time. What are the consequences if the corporation just blows that tight deadline?
Well, this is where it gets interesting. The law actually protects the buyer, not the corporation. If they fail to deliver that certificate on time, the unit is legally considered clean. Yep, the buyer can just assume there are no debts, no surprise special assessments coming. Basically, the law protects the buyer from the corporation's incompetence.
All right, let's switch gears. Section 2, the true worth of property. We're going to talk about how investors really calculate value. And let me give you a hint. It has nothing to do with curb appeal or a fresh coat of paint. For an investor, it all comes down to cold, hard numbers.
So, picture this. You've got 2 identical buildings, side by side. Building A is owned by a widow completely debt-free. She owns it outright. Building B is owned by a speculator who is mortgaged up to his eyeballs. So, are these 2 identical buildings worth different amounts? The answer? Absolutely not. A professional appraiser or a savvy investor, they don't care one bit about the owner's financing. The building's value is intrinsic. It's all about its ability to generate cash, totally separate from the owner's personal debt.
And it all boils down to this formula right here. The key part is that NOI, net operating income. That's the cash the building generates after you pay all the operating expenses, but, and this is the crucial part, before you pay the mortgage. The value is in the asset itself, not how the owner paid for it. Okay, on to our third section, and this is a big one. The myth of easy eviction. This is one of the biggest friction points in all of real estate. So many landlords think it's a simple process, but you have to understand, the law in Ontario is built to protect the tenant.
It all starts with this core principle called security of tenure. And what that means is the tenant comes with the land. So if you buy a property that has a tenant, you don't just buy the building, you buy the tenant too. That lease is attached to the property, just like an easement would be.
So, what if you, the new owner, want to move in? You have to use a special form, the N12, and give 60 days notice. But here's the catch. The process is incredibly strict. That 60-day termination date must be the last day of a rental period. Usually, that's the last day of the month. If you're off by even one single day, the whole notice is void. You have to start all over.
And that own use reason, it's defined very, very narrowly. It can be for you, your spouse, your child, or your parent. That's it. Your cousin? Nope. Your best friend? No way. Business partner? Forget about it. The list is short and the law is strict.
Now check this out. This is a really fascinating contrast. To evict a tenant for your own use, you give 60 days notice. But to raise their rent, you have to give 90 days notice. Think about what that says. The law gives a tenant a whole season to adjust their finances or find a new place to live. It really shows you just how much tenancy is protected.
All right, our final section, what you don't really own. This is where we look at those hidden limits, especially on rural and new properties, where what you see is definitely not always what you get. So let's say you're building a brand new home, but you're using part of an old foundation. You have to be super careful. If you keep more than 40% of that old foundation, the Tarion New Home Warranty Program says, nope, that's a renovation, not a new build. And boom, just like that, your warranty's gone. And for anyone who's ever dreamed of that perfect cottage on the lake, here's a real shocker. Buying a waterfront property doesn't always mean you own the actual waterfront.
Yeah, it's wild. In a lot of places, the government actually held back a 66-foot strip of land right along the shore. It's called the Shore Road Allowance. This means your dock, your boathouse, it could technically be trespassing on public land. You absolutely have to get a survey to know for sure. You see, all these little things, mixing up 60 days and 90 days, valuing a building based on the owner's mortgage, not checking for a shore road allowance, they might seem like small details, but they're not. These are the exact friction points where really expensive, really draining lawsuits begin. So if there's one thing to take away from all this, it's that real estate law is procedural, not intuitive. You have to do your homework, you have to do your due diligence. And that leaves us with one final question for you to think about. What common sense rule are you following in your own life that might be completely and expensively wrong?